Okay, we're now in session 21 of the U.S. government. We're talking about the amendments to the Constitution. We've been working our way through the Bill of Rights. Back to your notes. We began a couple of weeks ago looking at these first 10 amendments that were added to the Constitution to secure certain rights for its citizenry. There's 27 of those amendments. We've looked at number 1, we've looked at number 2. Today we're going to pick up with number 3 and walk through 2 or 3 of them. One of the things that we need to be reminded of is from time to time, as the nation progresses and as situations and things change, that there has been a process established in the Constitution for how we amend it. The rights, I put this in your notes, I left it there from last week. The rights guaranteed under the Constitution and specifically in the amendments and the Bill of Rights apply only to citizens. They are not applicable to governments or states or other public and municipal entities. These are only individual personal rights. And so we're going to pick up with, and probably even just as a casual student, you're familiar maybe with number 1. You're probably familiar with number 2. If you've paid much attention, you may be familiar with number 5, which we'll get to as we go forward. But as we transition, we're going to begin to look at some of these. Number 3, and it's in your notes, just let me read it to you. The Third Amendment says, "No soldier shall in time of peace be quartered in any house without the consent of the owner, and nor in time of war, but in a manner prescribed by law." Now, in the culture we live in today, that's kind of far-fetched for us, but this amendment does more than just forbid the forced housing of soldiers. It literally sets up the concept and the protection of a citizen's private property. During the Revolution, it was a common practice because the British would ship soldiers over to the colonies, and then in order to provide for them, they would simply mandate that citizens would take those soldiers into their homes, and they would have to provide space for them to sleep, food for them to eat, and meet the daily needs, regardless of the impact that it had upon the citizens, regardless of the fact that the citizens may or may not want to be involved in that. This forced housing was seen as a great insult and an intrusion into the rights of citizens. Again, 1791, there is, in reality, early on, there was 2 camps in the United States. There was the one who had the context they call the Federalist, that really believed in a strong central government. And then there was the group called the Anti-Federalist, who believed that the federal government needed to be mandated to be limited because there was a fear that somehow in this new constitutional republic that there would be those men who would abuse the power and literally replace the English crown with an American form of government that would force the citizens to live in the same kind of subjection that they found under the English rule. And one of those things had to do with housing. And so the role of protecting your personal property is what flowed out of this. Described by some as a preference for the civilians over the military, the Third Amendment forbids the forcible housing of military personnel in a citizen's home during peacetime and requires the process to be prescribed by law in a time of war. This amendment is not considered controversial and has never been litigated before the Supreme Court. Since 1791, there's never been a case that's gone through the process that has made it all the way to the Supreme Court. Now, we'll look at this in a little bit. There have been cases in which this amendment was applied, but they always were settled before it got to the Supreme Court. Because you and I know in our culture today, we have a structured military. We have armed forces who literally within that housing, food, medical care, all those kind of things are provided with the framework of the U.S. military. And so it's not been an issue for us. The amendment was not focused so much on foreign troops. Now, again, in war, when a nation conquers or an army conquers a land, it's very common for them to scour the country, to take supplies, regardless of the needs of the people. The old adage is they pillage the village, so to speak. To make it right or wrong, that's a different story. So this was not put in place so that if Britain were to attack the United States again, if during the Civil War, which they had no idea was coming, if there was another war in which that another country attacked the United States, it was illegal for them to board their soldiers in houses. That was outside the scope of the law. What it said was that in the United States government cannot take advantage of a private citizen's personal property. This amendment was not focused on foreign troops, but on U.S. troops being forced by the government to be allowed to reside in private houses, even in times of war, except in accordance with the laws of the land. The U.S. Constitution wasn't the first document in the colonies to establish that. Again, in those days, prior to the U.S. becoming a country, each state had its own legal system. Each colony has its own governing body, and one of the things that you find over and over again in that is the fact and the place of this issue being a part of those state constitutions. For example, in looking at your notes, the Articles of Declaration and Resolve from 1774 made a direct statement to oppose such a practice in place. Again, before the Declaration of Independence was signed, 2 years before that, in 1774, there was an article written by the Continental Congress that declared, it's called the Articles of Declaration and Resolve. Here's things that we cannot, even as British subjects loyal to the crown in the colonies, we cannot accept these things as being acceptable to us as colonists. In that was the housing of troops. In the Declaration of Independence in 1776, the signers again mandated, as a reason for the move to independence, the quartering, and this is what they said, of large groups of soldiers in private homes. One of the reasons that they said we can no longer find ourselves to be subject to Great Britain is because of this process and this practice. So it was a really, really important deal, just as it would be today. If you go home and suddenly the National Guard pulls up and unload a truck and they say, okay, as of today, these 3 soldiers will be staying at your house. You provide them a bed, you provide them with food, you provide them with the necessities that they need. Oh, by the way, we're not paying you a penny. This is out of your pocket. And so the disruptions like that would be completely unacceptable today by you and I, just as it was in those days. In the same year that the Declaration of Independence was signed, 1776, the Delaware Declaration of Rights stated this on a state level. Not just, remember, the Constitution and the Declaration of Independence was on a national level, on a state level. In Delaware, in 1776, it said, the Declaration of Rights said this: no soldier ought to be quartered in any house in time of peace without the consent of the owner, and in time of war in such a manner only as the legislature shall direct. Almost verbatim what we find translated and found in the Constitution of the United States, we find in the Constitution of Delaware, and you find the same thing in several others in their states. It was so important to the new federal government as to be added as the Third Amendment in the Bill of Rights in 1791. Again, we had the Declaration of Independence, but in this Bill of Rights, the first 10 amendments it was guaranteed. The third most important thing that the legislatures found to be important was this no quartering amendment. And so it's been vitally important for that to happen. Now, the truth is, no case has ever reached a direct case on this. Now, there have been at least two major cases in which the Third Amendment was referenced. It was used as evidence, but it was never a challenge because this has never happened in the United States. In 1965, the top of the next page, the concept of this case was used as an inferred defense in the case. And in 1952, it was presented as a defense of a case of seeking limitations to the ability of the president to seize private property. For example, in 1952, the federal government pursued a case. Again, be reminded, in the early 50s to the mid to late 50s, there was this huge push by the federal government to root out communism. And so one of the things that happened is that there was this broad mandate given by the government that people could go into people's house and began to do some things. The case did not have to do with the quartering, but it had to do with the concept of a person's private property. And so this case that actually reached the Supreme Court had to do with limiting the ability of the president to set up a task force that could come onto your private property and seize your assets. Again, it was not a challenge to the Third Amendment, but it was a reference to the Third Amendment to give credence to their position. Okay? And it was successful in both cases to prove the point to the case that a person's private property cannot be invaded by the federal government without. We'll get to the Fourth Amendment and Fifth Amendment as we go. So that's the Third Amendment. Amendment number 4, and it says this, and I'm going to have to get it up here and read it because I can't read that far. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be searched, to be seized. Now, again, it was common in those days that the government, if they had a thought, now specifically in the colonies, remember, in those days there was a rebellion, open rebellion against Britain, and the Patriots, the Minutemen, those that were ready to fight the battle, were in open rebellion. And so the British government gave open-ended abilities for their soldiers, their troops, their forces, if they even thought that you might have some contraband or you were a patriot, to come into your house without notice, without any reason, and to seize your property, to completely violate any personal rights that you have. And as a result of that, there was a demand that the new government, again, remind you, all of these only apply in relationship between the individual and the federal government. Now, the states have now complied to that as well, but the context of that was that the federal government can't roll up onto your property, come out because they think you might be able to have some illegal whatever. They have to have due process. They have to have a reasonable cause, and it has to be approved. And so we'll talk about, but the concept was this, that it would protect your person, your rights, your things. During the time of the British forces being in the colonies, and especially as the fervor and for independence began to grow and spread, the British soldiers would use force that they held to force entry into and search private homes. They used what was called the writs of assistance, and general warrants that was used by the British were pointed to as being both illegal and unfair to citizens in the colonies. They didn't have to have what we would call reasonable doubt. And so literally, it became the process of the soldiers and the army and the military to just sweep down on neighborhoods and just walk their way through every house, upset everything. They could take whatever they wanted if they thought it proved to be a contraband or proved to be something that could be used against the British soldiers. They could arrest people and haul them out if they even suspected that you were part of the rebellion. And so the government in England had began to issue in two things: the writs of assistance and general warrants. And so what this does is says, no, this is not going to, this can't happen in the United States. They could indeed use such tactics to seek out and capture colonial leaders, goods, provisions, arms. Anyone suspected was liable to find their doors forced open and armed soldiers destroying their goods and property looking for those items. Now what we're going to see on this, that out of that has flowed a set of private individual property and personal rights. We'll get to some of that in just a second. As with other amendments, many state constitutions had already declared this protection for the citizens of the states. The Bill of Rights, the amendment in the Bill of Rights guaranteed no private citizen's home or property could be searched or seized without justifiable reason and lawful consent. It says, if I believe that you are harboring illegal weapons, that you're manufacturing illegal substances, if you're practicing slavery in the sex trade, or you're transporting illegal aliens, before I and the law enforcement can come and do an inspection or do a search, is I have to have probable cause. And again, on a federal level, then a request for a warrant has to go before a judge or a grand jury, and the grand jury has to say, okay, there is probable cause, and they will issue the warrant that I then can come and take and come and do the search. But I can't, just because I think something might be there, or I think you might be a bad person, or I think this, the federal government has no jurisdiction to do any of those kinds of things. The warrant was the term used and is still used to describe the official document used to lawfully conduct a search. The warrant is designed to, now, and so here's the other thing that's important. I can't just go say, hey, I want a warrant to go search for whatever I might find. A grand jury has to issue a warrant that lists specifically why, what the evidence is, where I'm going to search. For example, there are times that if I'm going to come and pull a raid on your house, and I search your house, but you've got another house 2 blocks over, I can't go from your house to the other house simply because they're your house unless the warrant from the grand jury tells me I have permission to search both this house and the other house. It has to be specific as to where I can search, and it also has to be specific into what kind of evidence or what I'm trying to accomplish in the confiscation. Now, the truth is this. If I come to your house looking for illegal drugs, I get a warrant. But while I'm there, I find a counterfeiting process, or I find a cache of illegal guns. That's not why I was there, but when they come to light, then I can incorporate that as to the process. So it's not like I come to your house searching for drugs and I find that you're smuggling illegals. I just have to say, well, I can't do anything about that. But the focus has to be on this is the reason and these are the particular places that we're going to search. Again, to protect an individual's rights. In order for a search warrant to be issued, a judge must agree there is sufficient evidence, probable cause, to point to the potential for finding what is being searched for. The rights of this amendment were almost unheard of outside of the new United States, and it's interesting, and in England. Not in the colonies, but in England herself. Matter of fact, today, there are a lot of countries that do not have the protection of search and seizure. Many countries out there, they come into your house when they want to. But in this country, if the police show up on your house and want to do a search, if they do not have a search warrant, they do not have the legal right to come into your house and search your property. Okay? All right. In the U.S. today, this amendment is used in more than just the traditional method of physically searching. The search and seizure of personal information that is digital or publicly published is also looked at. Again, when this was written, there was not anything out there concerning the internet or things that might be posted. The first case to be heard by the Supreme Court was Holman versus the United States in 1928. Now again, we're not talking about the first case concerning search and seizure, but in the use of technology, phone tapping, wiretapping. For example, in 1928, the Homestead versus United States. We're in the middle of an era in which that organized crime was rampant, and the government, on a federal level, came in and set a wiretap up on a phone line. Now, the wiretap they did was not in the house where they were going to. It was on the phone line under the sidewalk in the front of the house. And they actually got the information they were looking for about criminal activity. And Homestead was arrested and convicted, and he appealed to say that that information that was gained was in violation of the Fourth Amendment because they had illegally searched and seized his property, his information, without having to have, without the proper process for doing that. The government was using wiretapping on phone lines in their battle with the mob. The individual accused said the government had unlawfully seized his private info by tapping the lines without a warrant. So that was the first case. As a matter of fact, that case, when it was heard by the Supreme Court, disagreed with him, which was kind of interesting. So his conviction was upheld. In 1967, in Cates versus the United States, the Supreme Court heard arguments that the rights of an individual, again, a gambler, in making transactions on a public phone, the government found that this guy was like a bookie or someone who is doing large-scale bets, but rather than using the phone at his house, because he knew that if they had probable cause, they could put a tap on that, he was using a public phone. The federal government realized that and put a tap on the public phone. Now, this was not his phone, this was a public phone. They heard arguments that his rights had been violated because of by putting a listening device on a public phone that he was using. So I'm now saying you can't use this because this is my private information, even though it's in a public setting, that you cannot simply abscond that and use it. The court agreed that the Fourth Amendment was there to protect individuals and not just their goods. Again, it's not just the fact that you're going to come to my house and take my stuff. It's the fact that what I am and what I say and what I think and what I do is private. And so they upheld that the fact that they had tapped a public phone, which gave them access not only to him, but anybody that used the phone in those days. That would like be saying that in the old days, because phones weren't like individual, a phone in a public cell phone or a public phone booth, whoever called, their information was being tapped into and received, and the Supreme Court said that's illegal. You cannot use that. In today's world of intent and the GPS, the understanding of intrusion without just cause has shifted, and the definition and scope of the Fourth Amendment. We now live in a world in which more information is transmitted via technology than by any other means. I'm not going to, if I'm looking for evidence that you're committing criminal activity, I'm not going to find as much probably in your house on a legal pad, a letter form, or a file cabinet as I am going to find on the cloud. And so the whole concept of what that looks like and the protection of that is much more in the forefront rather than the Third Amendment. So very quickly, let's look at the Fifth Amendment. The Constitution. The Fifth Amendment says, no person shall be held to answer for a capital or otherwise infamous crime unless on the presentation of an indictment of a grand jury, except in cases arising in the land, on naval forces, or in the militia, when in actual service of times of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor shall be deprived of life, liberty, or property without the due process of law, nor shall private property be taken for public use without just compensation. Man, there's a long list here. And again, this is a compilation of things that were going on that was decided. Look, these are private, personal guarantees. So this amendment deals with the protection from criminal proceedings. It deals with how citizens' rights are protected. And so when you look at this, what we find is several things. The first facet of this is this. The amendment bars a citizen from being held in any way without a decision being made by the grand jury, and that there is sufficient evidence to support the action of the arrest and holding of the individual. This document is only dealing with federal government. Again, it was not uncommon for folks to be arrested. It was almost the concept of guilty until proven innocent. In our court system, you're innocent until proven guilty. There has to be an indictment made. That means that their evidence has to be presented, and a justifiable set of evidence has to be approved by a grand jury in order to hand out an indictment. If there is not, if the charges presented to the grand jury are insufficient to prompt arrest, then the jury will do what's called acquitting the case. And many times that happens. Does it mean the party's not guilty? Not necessarily. It just means there's not enough evidence to support charging them. So that's the first part. You cannot be charged for a crime without the evidence and the approval of a judicial process for you to be indicted and you to be arrested and you to be proven guilty. The second facet of this amendment specifies anyone in the armed forces, again, in the military rather than a civilian, who commits a criminal act will be tried by a military court in a court-martial. The armed forces have put their own laws and punishment for those who break those laws. These federal cases fall under the U.S. Court of Military Appeals. If a military situation happens, the military courts are the one that handle that, which is separate from the normal civilian judicial process by which you and I live under. Okay? Number 3, by the way, that means that you as an individual live not under a military law, but you lived under a civilian judicial law. Number 3, the third part of this amendment, which is vital to the rights of individual citizens, is the forbidding of multiple arrests and trials for the same crime. Basically, you are tried for murdering your great-grandfather, and you're found innocent. You cannot, because the lawyers, the government didn't like the case, they cannot come back and arrest you and charge you with the same crime over again. Regardless of whether you're proven guilty or innocent. If you're proven innocent or acquitted, then that case is settled. Now, if in the fact that you're now found innocent of killing your grandfather, but there's multiple murders, then you can also then be charged on a separate count of murdering your grandmother, and the trial goes over again. So while there can be multiple charges from a single crime in the context of the processes, you cannot be, it's called double jeopardy. You cannot be tried for the same crime at the same point multiple times. The second part of that, in a court case, when an individual is found innocent, he cannot be tried again for the same crime. It doesn't mean if a person is found innocent of murder in a specific case, he can't be tried for murder again in another case. Only in the case he was found innocent. So what you find sometimes is a court case where there are multiple counts. You're found on a federal case. You're found murder of this person, murder of this person, attempted murder of this person, carrying an illegal weapon, whatever. So there's multiple counts, and each one of those counts then is determined on its own merit, and then a determination is made. And so sometimes in a case, federal case, you're going to find that the jury may find this person innocent of count A or count 1, count 2, guilty of count 3 and 4, and not guilty of count 5. But whatever it looks like, you cannot be tried a second time for the same crime. The phrase, nor shall be compelled in any criminal case to be a witness against himself. This is probably, if you're familiar with the Fifth Amendment, the part that you're most familiar with. It says this: if you're on trial for a crime, you cannot be mandated by the court to get on the stand and give evidence in which that it incriminates you for the crime. And so many times in high profile cases, what you'll find is someone ask a question and they will say something like this: in accordance with the Fifth Amendment, I plead, in accordance with the Constitution, I plead the Fifth Amendment. Which means I'm not going to answer that. I'm not going to allow you to self-incriminate me. Okay? He can't be forced to give testimony that would incriminate himself. This phrase is used many times in cases where the individual knows the answers, but if he answers it, it will bring evidence against him, and he simply or she simply will say, I plead the Fifth Amendment. Okay? Hurrying on, the amendment also guarantees no person can be held for a crime without due process or speedy remedy of the charges being made. I can't come and arrest you for a crime, put you in prison, and leave you there without proceeding with the processing of that crime. There's due process. That means I have to advance this case in a timely fashion and in a way that expedites either innocent or guilt in all of that. The last phrase deals with the seizing of private property by the government. No personal property can be taken from a private citizen for use by the government without the government giving a fair and just compensation. You live over in Conroe. The federal government says we're expanding Highway 105, and we need for not Highway 105, but Interstate 45. Interstate Highway is a federal road. 105 is a state road. But to expand 45, they need more property. They simply cannot come in and take 50 feet off the front of your property and say, sorry, we're just doing it. They can come and say, we're going to have to take this, but we will give you a fair and commensurate price for the property. I have a friend of mine that happened on 45. He had a business over there, and they took the first 20 feet of his property. He ultimately had to close the property because he had no frontage, and they had to tear down his building. But they compensated him well for that. So in the midst of that, this Fifth Amendment guarantees so many things that are important to us. Okay? All right, next week we'll pick up again. Have a great week.